Good morning, good afternoon, and good evening to all you delegates taking part in this working group 2 colloquium on possible future work in dispute settlement. We had a very active discussion yesterday on elements that could contribute to scoping the work on technology-related disputes. And we will continue discussing technology-related disputes, and we're going to look at 2 more provisions, draft provisions this morning, and 3 more draft provisions this afternoon. So I'm giving the floor to my colleague Jay, who is going to moderate the discussion, and he will kick us off for the day. Thank you.
Thank you, Anna. As you just indicated, first we'll be looking at the different timeframes that is to be applied to technology-related disputes. This is particularly draft provision 4 and draft provision 9. A question that we had, and I think it was kind of implied in our comments yesterday, was how and whether the expedited rules, the timeframes in the expedited arbitration rules, for a shorter time frame for submission of documents, submission of statement of claims, statement of defense, and 6 months time frame for rendering the award could be applicable in the context of technology-related disputes. So we would like to invite the 3 experts who prepared and was active in the preparations of draft provisions 4 and 9, and hopefully they are online. Gillard, Raheli, and Tillman. Could you please raise your hand so that we can give you the floor? Yes, Tillman, could you please take the floor? Tillman, you have the floor.
Oh, thank you. I was on mute, and thank you. Distinguished representatives, it's a great honor and pleasure to participate in this colloquium, and I would like to thank UNCITRAL for inviting me to speak today, albeit from Munich and not from New York, unfortunately. Together with my colleagues and friends from law firm Herzog and Tel Aviv, Dr. Hilad Weichselmann and Dr. Raheli Pri-Reichmann, we will address the time frame under the proposed rules for technology disputes. The definition of technology disputes in Rule 1, Paragraph 1, is inclusive, and as can be seen from Paragraph 2, this definition would cover a broad variety of disputes. Looking at the time frame under the proposed rules, the rules provide for very short time limits. Pursuant to Rule 3, the initial case management conference has to be held as soon as possible. And pursuant to Rule 4, any supplements to the request for arbitration must be filed within 5 days, and any reply to supplements with another 5 days. Pursuant to Rule 9, the time period for making the arbitral award is 20 days from the constitution of the arbitral tribunal where a decision is rendered on document-only basis. and 40 days if a hearing takes place. There is a possibility to extend this time period, however, with a maximum period of 60 days. And finally, Rule 9 also contains a sanctioning mechanism in case the arbitral award is rendered late. This setup is considerably stricter than the vast majority of existing arbitration laws and rules. Arbitration laws generally do not contain any specific time limits for procedural steps, unless the parties have agreed on this point directly or by reference to arbitration rules. This issue is left to the discretion of the arbitral tribunal. Arbitral institutions increasingly include time limits into their standard rules. One of the first institutions to do so was the ICC, with a 6-month time limit for rendering the arbitral award, starting with the signature of the terms of reference. While the purpose of the provision at the time was to ensure the enforceability of the arbitral award under certain arbitration laws rather than to increase the speed of the proceedings, today many institutions have included time limits for increasing the speed of the proceedings and to accelerate the proceedings. The German Institution for Arbitration, DIS, for example, which has recently revised its rules, has included a 3-month time limit for rendering the arbitral award, starting with the hearing or the last submission in the arbitration, whichever is later. The reason for the increased awareness is that over the last 2 decades, the length and costs of arbitration proceedings has been identified by users as one of the main disadvantages, and many institutions therefore have set up expedited arbitration rules in addition to their standard rules. Likewise, UNCITRAL has recently adopted the expedited arbitration rules. Some of these expedited rules apply by default. For example, the ICC accelerated arbitration rules apply in disputes with an amount of up to $3 million by default. Other rules, such as the UNCITRAL expedited rules or those of the DIS, require that the parties expressly opt in. Now, with regard to the high-tech sector, it has been observed by users, both on the business and the legal side, that often the need for speedy proceedings is particularly urgent. In some areas, the development of technology is so fast that unless a speedy decision is rendered, justice delayed amounts to justice denied. And furthermore, notably in the startup tech sectors, founders are looking for pragmatic, low-cost dispute resolution solutions. They consider arbitration in its standard form as unsuitable for their highly agile way of doing business, and therefore often try to avoid it. But also in the high-tech sector, you find highly complex disputes with very high amounts at stakes. And these disputes often are not suitable for expedited arbitration. Instead, these disputes require an extensive evidence-taking phase. In these kind of disputes, the case management skills and the sector experience of arbitrators can be by far more important than the speed of the proceedings. Applying an overly rigorous time frame to these kind of disputes risks to create inefficiencies, frustration, and overall unsatisfying results. And therefore, one should abstain from applying a one-size-fits-all approach in the field of high-tech disputes. This raises the question of how to identify and implement the right time frame for a particular case. And as a matter of principle, priority should be given to the choice of the parties. The parties know best the details of their case and therefore are in the position to decide to what extent the speed of the proceedings is important to them as compared to other aspects. If the parties agree on certain time limits, these time limits should be applied to the case. However, where the parties have not made any arrangements, the time limits need to be determined based on the applicable rules. If the rules do not provide for specific time limits, they need to be fixed by the arbitral tribunal or the institution. And often the view of the parties will considerably diverge once a dispute has arisen. In such a situation, a pre-formulated set of procedural timeframes could be a helpful tool for the parties and the arbitrators to establish a suitable timeframe for their particular case. And one could think of the following mechanism for the proposed high-tech rules. Based on the first round of written submission, the arbitral tribunal in the initial case management conference, or even before the constitution of the arbitral tribunal, the appointing authority categorizes the dispute based on the available information on the case. Based on this categorization, it will allocate the dispute to, for example, one of three pre-formulated set of rules. These could be a standard set of rules like the UNCITRAL arbitration rules, an expedited set of rules as the UNCITRAL expedited rules, and if there is an urgent need for speed, fast-track rules as the time frame proposed here for the high-tech rules. Should it turn out during the arbitration that the time frame is unsuitable, the arbitral tribunal could change the time limits upon consultation with the parties during the proceedings. These would be my thoughts on the proposal, and I would now hand over to my colleagues, Gilad and Rachel.
Thank you, Tilman. We are trying to see if our colleagues Raheli and Gilad is joining. We do not see them on the screen, but if you can, could you raise your hand so that we can identify you? In the meantime, I would like to open the discussions on draft provisions 4 and 9. I think what Tilman was trying to tell us is that there are default rules that could be used by parties in the case that the parties are not able to agree on a set of time periods to apply to their disputes. For example, she was also mentioning that the appointing authority could have a role in determining which timeframes would be the most applicable to the dispute at hand. And he also highlighted that the arbitral tribunal would have the discretion to change the timeframes in the case that the timeframes that has been decided by the parties or even by the appointing authority is not suitable for the dispute. But with that at hand, and while we're waiting for the other speakers to join, I would like to give the floor to Switzerland.
Point of order. What is the exercise about? We're having a set of rules which obviously are not complete set of arbitration rules. We don't know how the arbitration is started. We know that there's a sole arbitrator, but we don't know how he or she is appointed. We have heard from the speaker just now the reference to the appointing authority. There's no mention of that. We don't know what submissions are made. Is there a statement of claim? Is there a statement of defense? We have reference to a hearing, but there's no rule on the hearing. We know at the time for completion, but we don't know how the 40 days can fit in any normal arbitration. We know that the arbitrator's fees are reduced, but we don't know how they are fixed. So what is reduced? So before continuing the discussion, it would be, from our perspective, useful to know whether these rules are a complement to some other rules. Are they a complement to the Silicon Valley arbitration rules? Are they a complement to some other rules, or do they relate to some of the UNCITRAL rules, the basic arbitration rules, or, as we heard, the expedited arbitration rules, because it is difficult to discuss rules, incomplete or rules that fit here and there in an arbitration without knowing to what rules these proposed rules, which indeed are interesting, but if you don't know what set of arbitration rules they refer, it is difficult to discuss the individual proposals. Thank you.
Thank you. The Secretary would have a response, but would like to hear from the delegate of Israel first.
Thank you, Chair, and thank you to the distinguished delegate of Switzerland for raising this point. Just to clarify, the idea that we see behind this project, and I've always seen from the beginning, is these are not separate arbitration rules. These are not meant to replace the UNCITRAL arbitration rules, nor to replace the expedited arbitration rules. And the idea is rather to do something that is different from what was done until now, because the high-tech dispute or the technology-related disputes are unique, as we heard, I think, yesterday from some experts, and as we have been hearing for the past 3 years, coming up in different events and different discussions with experts and with industry. So the point is, and I think it's very clear, we think it's made very clear in the Secretariat's paper, as that these are provisions that would allow these are model provisions which could be incorporated into dispute resolution clauses. They could be incorporated as a whole, but which would maybe be the regular way, but what we are aiming for is not for this. So the idea is that if parties envision or they think that there could be a technology-related disputes, they could pick and choose from these provisions to be incorporated into their clause. So, for example, we can have a dispute resolution clause that will refer to the UNCITRAL arbitration rules, or even to institutional rules, but also to the confidentiality provision in one of the provisions that we have in the draft, or to the timelines which we are discussing now, or to the digital evidence which we'll discuss down the road, or to the conference management service. So this is the purpose. We know it's something that's non-traditional for UNCITRAL to do. We know it's something that's different, so maybe we should really be all on the same page. But the idea is that these will be a collection of rules that parties can pick and choose from. So in that case, we don't think there is a need for additional elements. However, we are of course open to anything, and we are open to changing the format, and we are open to make it more traditional if it helps. But we think that this is this is a very good example why these provisions or this project should be discussed by Working Group 2, exactly to hear these kinds of comments and to see how we can work on something that will be, on the one hand, similar to what UNCITRAL has done before, but on the other hand, innovative and different in order to address the flexible needs of the high-tech community. So hopefully we were able to respond to the distinguished delegate of Switzerland, but we'll also be happy to hear from the Secretariat or from others. Thank you.
Thank you very much. And thank you to the distinguished delegate of Switzerland for raising this point of order, and also to the distinguished delegate of Israel for giving us some background on the project and why it is being discussed in this colloquium. We are still, as I mentioned, in a colloquium format, and so we are more in the brainstorming format. This project has been presented to the Commission 2 years ago. It has already been discussed in various expert meetings. It has been analyzed further in conjunction with the broader dispute resolution in the digital economy project. And what we found useful in terms of methodology, in order to better grasp the specificities, and also better in order to see how best to respond to these specificities from the point of view of an UNCITRAL working group, and see if there is indeed something for a working group to do, or if this can be dealt with by industry or by a group of experts, and later be brought to UNCITRAL when it is more closer to what UNCITRAL does. So in order to better conceptualize, we thought that it would be useful to start looking at actual clauses and to from there identify what is specific to these disputes. And as the distinguished delegate of Israel mentioned, the specificity of the needs, at least as they have been expressed in the previous expert discussions, where a need for speed, a need for technical expertise of the arbitrators or the third-party neutral that is being involved. There were issues of confidentiality, of evidence in the digital context, and of course the ever difficult issue of how to define what we're talking about. So in order to be more concrete and to really allow this colloquium to discuss the concept itself, we thought that it would be useful to put it in the form of these clauses that are, of course, totally disconnected from any existing UNCITRAL text for the time being. And we would then see, once we have identified better whether something is to be done by UNCITRAL, then we could see and we could discuss what the form of these clauses could be, whether they would be only a set of clauses to be included in a contract when we have tech disputes, or whether they would actually be linked to existing UNCITRAL text, but we are not yet there. And from the different discussions we've had so far, we understand that there's still a need for a better conceptualization, but that was the attempt.
Yes, thank you, Anna. Just to supplement Anna's intervention, we did not touch upon the form of the instrument in this document because we were looking at the specificities in substance. The question that we have as a brainstorming is whether we want to include a shorter time frame for technology-related disputes, whether there should be sanctions, for example, that is provided in Article Draft Provision 9, Paragraph 4. Of course, the interaction with the UNCITRAL arbitration rules and the expert arbitration rules would need to be considered once the substance of the rules, or if it is to be included as a model arbitration clause, it could supplement the model arbitration clause that we already have for the UNCITRAL arbitration rules and the expert arbitration rules. So the interaction would need to be reviewed at a later stage. But as Anna mentions, as a brainstorming session, we wanted to see if there's an appetite in the room to actually seek a shorter time frame, and whether there is any appetite for imposing sanctions for any delays in rendering of the awards. With that, I have just been informed that the two speakers that were supposed to be speaking on this provision is not available now and can only join in the afternoon session. So we will hear from the other experts, and then we'll try to give those experts, those who are not able to speak now, the chance to intervene in the afternoon session. With that, I'd like to give the floor to Switzerland.
Thank you very much for these explanations. I think that is a very useful exercise, but if you look at the individual clauses, most of them are of a nature that they could, with minor changes, apply generally. If I take the subject of yesterday's discussion of the case management conference, apart from a few words, these are very useful for any case management conference. So if we're doing this exercise, would it not be appropriate to see whether these are clauses that one could pick for any arbitration? For instance, if you say, we discussed yesterday the secretary. The secretary has to have technical, technical expertise. The expertise that was mentioned for the secretary, that is to say, manage a virtual hearing, have the computer, have a platform for the arbiter. These are qualifications any secretary needs nowadays. So such a clause would be useful in any arbitration. Time limits. There are, if you have a commodity arbitration, these short periods would be very useful and applicable. In a sorry, in a technology-related dispute, if it is related to an M&A dispute, as we heard yesterday, you probably need more. So I wonder whether the discussion about these clauses, of which some are very useful, really are just whether we have to restrict it to technology-related disputes, or whether they are not of an interest for arbitration in general, and where we consider different types of disputes which may need or may not need such clauses. Thank you very much.
Thank you. I'd like to give the floor to Singapore.
Thank you, UNCITRAL Secretariat and the experts who put together the draft provisions for tech-related disputes. From the presentations that have been made, we can see that a lot of thought has been put into the drafting. And the Singapore delegation notes that the draft provisions seek to take into account the unique features of tech-related disputes, especially in emerging areas where more expedited resolution of disputes is shown to be warranted. The adoption of arbitration as a dispute resolution mechanism seems generally well suited to the needs of B2B disputes involving technology and subject to our further deliberations on the definition of what constitutes tech-related dispute, given the often international nature of these disputes and the favorable international enforcement regime under the New York Convention. With the rapid technological developments and the technical considerations that tech-related disputes may merit, the provisions for expedited timelines and the appointment of experts with the appropriate technical expertise, among others, may help facilitate expeditious resolution of such disputes. That said, the working group may wish to consider the following points. First, while the need for more expedient resolution appears to be assumed, we wonder if there is a need to consider whether the deep and technical nature of issues involved, especially for technology that is emerging, evolving, or not widely adopted, may require more time for adducing evidence or examination. In that regard, we note the 5-day default timelines in the draft provisions. It may be useful to consider how these default timelines were calibrated versus the slightly longer but still expedited timelines in the expedited arbitration rule, and the scope of application of the expedited arbitration rule if shorter default timelines are available under the draft provisions, assuming they are alternative sets of rules. Further, while we appreciate having a fast-track process, we wonder whether in practice this may mean that parties end up with a fast but not as thorough a process as they might have wanted. This may be particularly relevant where tech-related disputes are novel or complex, or involve multiple parties across jurisdictions, or involve large amounts of data for which time is needed to put in place suitable safeguards or to agree on a confidentiality protocol. Perhaps it would be useful to consider whether such timelines are feasible and whether more flexibility on timelines could be built into the draft provisions. And conversely, for issues involving technology that are well established and adopted, we may wish to further consider if the need for an expedited dispute resolution process that is shorter than what is provided in the EAR is as compelling. Thank you.
Thank you. Is there anybody else who'd like to take the floor on the timeframes? We have Jaemin Lee from Korea.
Thank you. Thank you, Mr. Chairman. First of all, I also would like to thank experts for giving us an overview of these draft provisions, which is very helpful and setting a good framework for the discussion. We realize this is a brainstorming session, and we also realize the flexibility to be given to the proposed provisions at this stage. And then we just heard the general idea of expedited nature and the proposed deadlines for these disputes. And then we would like to note the scope of technology disputes set forth in draft provision 1, as we discussed yesterday. We remember that the scope of technology disputes seems to be quite broad. It spans over a wide range of areas, covering wide range of topics and wide range of situations relating to emerging or conventional technologies. So perhaps some disputes could be simpler, but some disputes might well be very complex, perhaps more complex than other conventional disputes. If that is the case, then the deadlines that we are considering could be, in some instances, workable, but in some cases could be quite challenging. So that's something that we could consider or contemplate in considering these issues from the brainstorming perspective. And we also would like to note draft provision number 5, which is about experts and neutrals in this proceeding who are supposed to provide reports to the arbitral tribunal. In our view, that process could take some reasonable amount of time, and we're also wondering whether these reports to be prepared by neutrals and experts could fit into the short time frame of 20 days, 40 days, or even 60 days. Thank you.
Thank you. We then have Israel.
Thank you, Jay. And thank you for the delegations who referred to this topic. We'd also particularly like to thank the distinguished delegate of Singapore, which we think really highlighted why we need specific provisions for technology-related dispute, especially because of the changing nature of these kinds of disputes, and the fact that in some cases you have emerging technologies, and in some cases you have well-established technologies, and we're not sure that this is, you can say this about every kind of arbitration. In respect of expediency, what we heard from the high-tech companies and from experts was that even 6 months, which we now have for expedited arbitration, or 9 months, is sometimes it's too long, and sometimes it could put obstacles on a project. And this also might be something that's relatively unique to the technological industry. And so we think these two components really call for a different kind of provision for timelines, and not the usual provision which we have in the expedited arbitration rules or in other rules which just sets a time, which is sort of a compromise between the regular arbitration and the expedited arbitration. In respect of the current proposals, we also are hesitant about the very short periods presented. We think they could be longer, probably something between 90 days and 120 days. And also, what is important is that we can have flexibility. So, for example, we could think of a provision which says that, and picking up on what was just mentioned by distinguished delegate of Singapore, that for well-established technologies, it will be a longer time or shorter time, and for emergent technologies, again, longer time or shorter time, whichever we discuss. And again, we think this could benefit from a discussion in the working group. At least I'm not aware of different timelines of this kind of flexibility in other timeline provisions. So we think that that is very important, and that is something that should be discussed. In respect of the other part, and in response to what you just said, Chair, about the sanctions, picking up on experience we had in UNCITRAL and discussions about sanctions not in an institutional context, we would not support including sanctions in this provision. But this is, again, something that the working group could discuss. But we think that this is yet another example of how the things are different. And if we relate back to what was mentioned, what was discussed yesterday and what was pointed out by distinguished delegate of Switzerland, we are not sure that the definition is similar to what we have in other, that we can apply it for everything. And also the case management conference, we remember that the proposal is not for the, as we understand it, not for the secretary only to have technological skills to do virtual meetings. It's for the secretary to have expertise in the high-tech field and to integrate the technical experts from the beginning and to identify issues, technological issues in the conference management process. So we do see some distinctions there. And we also like to highlight that even if the product, at the end of the day, the headline will be that these or UNCITRAL recommends the use of these provisions or some of them in technology-related disputes, this would not prevent anyone who wishes to use these rules in any other kind of arbitration. It would just be a signal that if you have a technology-related dispute, it is recommended by UNCITRAL, by General Assembly, hopefully, that these provisions might be considered. But it doesn't mean that you couldn't use them in other contexts. So that's why we believe that if we will work on this project, it will be beneficial not only for the technology-related disputes, but if echoing what the distinguished delegate of Switzerland said, it could be beneficial for every kind of dispute, but still preserving and echoing and addressing the needs of the high-tech industry, which I think is what we are trying to do here, and the timelines, the timeline provision is an example of that. Thank you.
Thank you. I'd like to give the floor to Switzerland.
Thank you. I have to say I found the explanations from the distinguished delegate of Israel highly useful, and if I may say so. I think what we want to look at now, we have heard the variety of disputes that are technology related. The possible approach to that, rather than putting 20 days into the time frame, or rather into another provision. The time frame doesn't even say that. It's in another clause where it says it. But rather than putting it there, to put in the case management conference provision that one of the subjects to be discussed at that occasion is the completion or the duration of the arbitration, the time for completion, and then put a very short period, like 20 or 40 days, as a target, so that the discussion at the case management conference between the arbitrator and the parties is not wide open, where one party wants to drag its feet and the other wants to push, but that there is a target which allows the arbitrator to put some pressure on the parties to act very quickly. So this delegation suggests that a time frame, that not be a fixed time frame, but that the time frame be one of the principal subjects for the discussion at the case management conference, and that there be given a target, a very short target, with perhaps the explanation depending on the nature of the dispute or the type of technology or something of that sort. Thank you.
Thank you. Before I have to give the floor to Argentina and France and Russia who have asked the floor, there's a comment in the chat from El Salvador also supporting what was said by Singapore, that we have to consider whether the shorter time frames for technology disputes is appropriate for technology-related disputes in comparison to the normal procedure that we have under the UNCITRAL arbitration rules. So with that, I'd like to give the floor to Argentina and then France. So Argentina.
Thank you for giving me the floor. Good morning and good afternoon to all distinguished delegates. I just have a question because I have some general comments to make, and I'd like to know if this is the appropriate time to do that, or will there be another opportunity to make those general comments later?
I think it's a good time. Please go ahead.
Muchas gracias.
Thank you. I'm just going to make some preliminary, very general comments on Working Document 224. This is an initial draft of positions, and the purpose is to consider specific mechanisms to resolve technology-related disputes. According to the working document, an expert would be called upon to consider the issue in depth. My delegation would have a question to put to the secretariat, and it's related to a clarification from the experts who drafted the provision. And we'd like to know if all of the legal traditions have been taken into account, and are they properly geographically represented? Do you have both? Did you include developed and developing country experts? That's an initial question I'd like to put to the Secretariat. Could the Secretariat respond to that?
Thank you very much to the distinguished delegate of Argentina for flagging this question regarding the composition of a panel of experts that would have supported the Secretariat in the preparation of the document. So we are not yet at this stage, at this formal stage of preparation of either preparatory work before it goes to a working group. We are still, as I mentioned before, in a brainstorming format. And in order to support this brainstorming exercise, because, as we mentioned, the project was not clearly delineated or conceptualized and could benefit from having some very concrete provisions, we prepared with those interested experts, the ones that have the expertise of this subject matter, some early research. So it is by no means an expert group meeting as we have them as the tools of work for the Secretariat when preparing a document for a particular working group. This project is not with a working group so far. It is being brainstormed. It has been already brainstormed in 2 years ago and last year with experts on the policy issues. We are now trying to formulate more precise concepts for these different provisions that would be relevant for these tech disputes, but we are not at the stage of an expert group meeting that would, of course, and obviously require that the experts participating reflect different legal systems and reflect a balanced regional distribution. So I really want to clarify this. This was an exercise that was carried out by the Secretariat in order to assist in the deliberations of today, and it is by no means a preparatory work for a working group, because the project has not been decided by the Commission to be given to an UNCITRAL working group. Thank you very much.
Would you like to respond, Argentina?
Thank you very much to the Secretary for those clarifications in response to my question. We have a second comment, and it's related to the purpose, if you will, of this draft. That is specifically setting up provisions for technology-related dispute resolution. We wonder about the need to set up a new rule specifically applicable to technology, with the understanding that the current and existing regulations, expedited arbitration, for example, which was approved recently, we understand and see these as more than sufficient for the effective implementation and resolution of these types of disputes. But as the Secretary has pointed out, this is really more of a brainstorming issue, and we understand that from that standpoint. Thank you.
Thank you. I'd like to give the floor to France.
Merci beaucoup.
Thank you. I wanted to thank Israel, Switzerland, and Singapore for their presentations, as well as the comments from other speakers. Just on the question of the time frame, I think, at least I have the impression, or I understand from what's been said, that there's no general rule or a single time frame to be imposed on all dispute resolutions. So, as I see it, since we can't establish a specific time frame, that time frame would need to be determined after the fact, and it would be up to the body to determine that date, either the arbitration court or the institution, but the arbitration court could be set up at the point of the case management hearings. I'm sorry, I need to find the French expression, or the case management procedure. And I think that perhaps we'd also need to impose, whether it's the court or the arbitrator, we need to have some kind of established time frame. And the purpose would be, the sole purpose would be that the time allotted is used effectively.
Un peu trop répandue, qui ne favorise.
But I'm not sure that this would necessarily lead to an expedited dispute resolution.
Thank you, France. I think that actually underlines one of the another question that we need to brainstorm, which is if there are to be timeframes, who would be actually adjusting those timeframes? Whether it would be the parties themselves, whether the arbitrary tribunal or the appointing authority or the institution administering the arbitration would have some say in adjusting it based on the circumstances. So I think that is also where we would like to hear comments from. With that, I'd like to give the floor to Russia.
Thank you very much for giving me the floor. Good afternoon, colleagues. secretariat, delegations. We would like to support those colleagues who said that, bearing in mind that the provision 1 of this document sets forth at this stage quite a broad list of potential disputes linked to technology. Therefore, it's necessary, in our view, to be quite cautious in how we approach the simplified time frame and in terms of the number of arbitrators that could deal with a dispute. So therefore, we'd like to propose to be more clear in our definition of a list of disputes in draft provision 1 because of their link to provision 4, so that on the time frames. And if a dispute is a complex one, for example, then the time frame proposed for that could be sufficient to look at this in detail. Also, we'd also like to support the possibility of looking at the document on expedited arbitration in the context of accepting technology-related disputes too. Thank you very much.
Thank you. Next on the list is Finland.
Well, thank you. Well, I would first like to thank in particular the Swiss and particularly the Israeli delegation for the explanations. I think they were very useful. I also would like to add my voice to those who had hesitation about these time frames, because we know that these disputes can be very different. So I think that Swiss delegate, if I understood him correctly, proposed that they should be fixed by the tribunal at for instance, at the case management meeting, and that would be a possibility. And so I think this would be a better. But these times as they now stand, I fear that we have to that we should not have such strict time limits here. Of course, I realize the need to expedite proceedings, but we have also tried to be realistic. So more or less, just to be brief and sum up, I more or less would echo what the distinguished delegate of France said, who just spoke a moment ago, without repeating every word he said. Thank you.
Thank you. There are no further requests for the floor. As I mentioned, we will have two experts who prepared the draft provisions possibly joining in the afternoon, so we'll give them the floor. But before we move on to the next topic, I would like to give the floor to the expert who prepared the Tillman, who actually, if you have any response. A request from Kuwait. I would like to give the floor to Kuwait first.
Firstly, I would like to thank all the participants in our discussions today. I would like to echo the statement made by the representative of France. It is important to establish timeframes and to guarantee that they are complied with. We do also believe that we really need to establish these timeframes in advance in order to reach swift solutions to these disputes. Moreover, we hope that the technology-related disputes will be resolved swiftly. We should also ensure that justice is respected. That's our main objective, of course. And we believe the fact that establishing a time frame, the idea of establishing a time frame is a good practice. But at the same time, the provisions on time frames must be flexible. Thus, the parties to the disputes and the arbitrators can have the opportunity to extend or reduce these time frames if necessary, or if, for example, there are extenuating circumstances. And we should also take into account these circumstances that could crop up. We should also have the possibility of extending, modifying, or shortening these timeframes. So I'd like to reaffirm the importance of what France said in this regard. We should respect these timeframes, of course. I also think that within these provisions we could include a number of measures that could guarantee the fact that parties won't use the possibility of extending these timeframes to badly, won't abuse this opportunity to escape any regulations. Thank you.
Thank you. We have the request from China. China, you have the floor.
Thank you, Jay. I know we are talking about time frame. Maybe what I want to say is about Article 9. That is, first, we think due to the complexity of technology-related disputes, maximum time limit of 60 days is too strict. Maybe as what's been said by Kuwait and others, there should be a flexibility about this time limit, and we recommend extending it appropriately. And also, about the arbitrator's fees may be reduced as punishment. We don't believe it has enough basis on rules, and it may also cause the parties concerned to deliberately delay the process. So we also recommend deleting this or further study it. Thank you.
Thank you. Tillman, would you have a response to the comments that were made with regard to the timeframes?
Thank you very much, Jay. And thank you for giving me the opportunity to comment on what has been said on the topic of timeframes. I fully share the need for flexibility that has been mentioned by several of the distinguished delegates. This is why I propose to include a mechanism to decide on the time frame once details of the case are known to the institution, to the appointing authority, or to the arbitral tribunal. I think one can discuss on what is the best institution to decide on this topic. In this regard, I want to refer to the caveat which has been included into the draft provisions. Before the definition section, it is stated that the rules have been prepared to stimulate discussion during the colloquium and therefore do not include mechanisms for parties to opt into the provisions, nor define the role of the appointing authority in determining whether such provisions are appropriate for the dispute at hand. I think it has become clear that this is a crucial issue which has to be dealt with. And I also support the idea to include this topic into the agenda of the first case management conference, unless the topic is disposed of prior, for example, by the arbitral institution or the appointing authority.
Thank you, Tillman. I think we've heard the views about the benefits of an expeditious resolutions for technology-related disputes, but also the need to preserve flexibility depending on the complexity and the nature of the case at hand. There were also some comments about when this, how and when the time frame should be decided, whether the appointing authority should have a role, and as Tillman mentioned, whether it is the parties that will be opting in to such provisions, or whether the timeframes would be a default provisions that would apply to such disputes as defined. So I think there are a number of issues to be resolved in moving this forward, which we will take on board. With this in mind, I would like to move on to the next topic, which is the appointment of neutrals and experts and the number of arbitrators. I'm just trying to see if there are any requests for the floor on timeframes. If not, I would like to invite the experts that prepared draft provisions 2 and 5, Chris Clemens and Krenguta, to present and explain why the draft provisions have been prepared in that fashion. Chris, you have the floor.
Distinguished delegates, members of the Secretariat, honoured attendees and fellow speakers, thank you for giving us the time to present on the appointment of arbitrators and experts in the context of technology disputes. My name is Chris Clements. I'm a forensic accounting expert witness in technology disputes. I'm also an arbitrator, a mediator, expert determiner, working across the globe for Deloitte. I'm joined today by Krenguta Lior, who is managing partner of LDDP, a large listed law firm, an arbitrator and counsel with experience across both investment and commercial arbitration. And she has a specific interest in technology disputes, which is going to be relevant today. I'd also like to thank Yoshihiro Takotori, who unfortunately cannot be here today, but was instrumental in the drafting of these provisions. Next slide, please. We will be breaking our session into two parts. First, we'll be discussing provision 2, which will be looking at the number of arbitrators, and this will be led by Krenguta, followed by a section on the appointment of experts and neutrals. Krenguta will continue through those, explaining the role of the arbitrator through those, before I take up most part of the way through to explain how we perceive the role of the experts, how they should conduct themselves, and how their evidence should be used. And at the end, I will close on further details of how a process of expert determination could also be used as an alternative in these procedures. Next slide, please. So over to Krenguta.
Thank you, Chris, and thank you, UNCITRAL, for allowing me to participate into this, as it was described, brainstorming. It is an honor. My professional background as practitioner is doubled by the fact that I'm a professor of international comparative law and a professor of law of communications and new technologies at the Bucharest University of Economics. Hence my dual perspective, law and technology. Now, looking from this dual perspective, law and technology, is where we have spent the most time in trying to discuss and identify the best solution in terms of the number of arbitrators. And two options were on the table. One was for an extended number of arbitrators, as to allow both arbitrators with a technical background, maybe as a majority, 2 of the 3, and the presiding arbitrator as with a legal background. That was option 1. And the other option, to have a single arbitrator, most likely with legal background, and then the appointment of experts to help that single arbitrator to be able to deal with the technical subjects in dispute were taken into consideration. So we had these two options. In choosing between these two options, the criteria that we used was the interest of expediency and efficiency. And for that reason, we considered that the default position, so unless the parties agree otherwise, should be to appoint only a single arbitrator and let then the parties provide this arbitrator with technical input via the appointment of experts. However, of course, consideration should be given as to availability and also as to the technical and financial expertise of this sole arbitrator. Of course, that the ideal would be to have as many as the needed professional requirements possible. Next slide, please. Now, You have seen the way in which we have drafted a provision here. And when and why would an arbitral tribunal or a party with the permission of the arbitral tribunal appoint an expert or a neutral or an expert determiner was the question that we had in mind in this respect. Our drafting highlights that it may be appropriate to appoint an expert on issues regarding the substance or the merits of the case, for example, where they are complex technological, legal, or financial issues. However, the use of may is indicated to indicate that it will not always be the right solution due to the experience of the arbitral tribunal and of the council. So if we have an arbitral tribunal which is qualified enough to understand the technical issues, then this might allow that tribunal not to be assisted by experts if there is not such a need. The draft provisions are deciding for a swift resolution to those issues that require specific expertise. And on that, we would like to have a side note, namely that this may result in procedural issues for the tribunal. And this situation, in such case, would have to deal with the procedural issues and to deal with the situation of division as to the extent that the discovery should be conducted, and such division might indeed have a different structure to the conduct of the proceedings. And finally, my last comment would be on this slide that in addition to expert or neutral evidence on specific issues, the draft provisions also allow for an expert determination on specific issues, which would allow, of course, the tribunal to have even more input of technical nature to its decisions. Next slide, please. And with this slide, I think I'm going to hand over to Chris to continue the presentation. Thank you.
Thank you very much, Conguita. The second paragraph of this provision on experts is focused on the process of who would actually be giving the permission to instruct an expert and what consideration should be given prior to the instruction of an expert. And the first point that we wanted to do was to make sure that it was clear that only the arbitral tribunal can confirm the appointment of an expert or a neutral, that not the parties. And this is deliberately done for reasons of expediency, so that you don't end up with a position of everyone having experts, including the tribunal themselves. And that would add to the time which was highlighted in the comments in the previous presentation. When giving consideration to that order, it's clear that what's required from the tribunal is whether the expert should be based on whether the expert is needed in the first place. It depends on the experience of the parties, experience of the council, and also, of course, the tribunal, as Conguita mentioned previously. It is also important that the information to be provided, and particularly issues around confidentiality. Everyone will appreciate that confidentiality in high technology disputes is absolutely paramount. And also some of the data protection rules and things must also be taken into account. So there must be a knowledge of the law and such points around the globe. And then finally, you must be ensuring that the timeframe for provision of expert orders must be tight, it must be expedient, it must be agreed between the parties for all the reasons that were discussed in the previous session. Also, apologies, there was a small typographic error that's highlighted on this slide, which was in the original drafting that unfortunately we didn't spot. Next slide, please. This was a very short paragraph, but an important one. It should go without saying that any expert appointed by the tribunal or the parties must be independent. That is sometimes challenging in certain specific aspects of technology-related disputes. I've certainly seen that there are certain aspects where there really are only one or two experts in the world in certain detailed areas. However, they really do need to demonstrate their independence in order to be not just be independent, but be demonstrably independent of the parties so that their findings can be respected and understood. Next slide, please. The fourth paragraph is all related to the disclosure. It is an unfortunate fact of experts that their requests for disclosure and additional information and documentation can add to the timescale. So our recommendation is that the experts should be provided with as much relevant information, but that information should be controlled and managed by the tribunal in a way to ensure that the whole process proceeds expeditiously. We are very aware that this has challenges to it in relation to who decides exactly what is relevant and what can be done. Certainly in my experience as an expert witness, it is occasionally required that you go back to a tribunal or a judge if acting in a court process and asking for additional information to be provided. Next slide, please. The fifth paragraph is that the expert on neutrals report should be admissible in any relevant proceedings between the same parties. There are a number of discussions at the moment in different fora than this, which is very live and pertinent to this point, which is saying that people should try and control costs to manage procedures by making sure that if there are parallel cases going on, that you don't have multiple sets of experts being instructed. One process should be allowed to be used across both. Next slide, please. Again, as an expert guiding a tribunal or an expert member of part of a three-panel tribunal, it's important to remember that in themselves, in that opinion, it is not binding. Of course, if once they're on the tribunal panel and part of the decision of the tribunal, then those findings become binding. But as an independent expert or neutral providing assistance to the tribunal, in themselves, their findings are not binding. And so we felt it was important to include that provision within the guidance. Next slide, please. The expert should be able to stand up for their opinion. They should be able to be cross-examined and tested and have that opinion tested by counsel of the parties if required. So if there are hearings held, they should be required to attend. Next slide, please. Fees and expenses, who should be paying for them? Well, we would propose that an expert and neutral appointed by the tribunal should be paid as part of the arbitral hearing. And of course, if the parties are given permission by the tribunal to appoint experts of their own, then those will be paid by the appointing party. We would not propose any additional provisions in that regard. Next slide, please. In addition to the position of having an expert, there is also an opportunity to use an expert determination process. An expert determination process differs from that of an expert witness in so much that the expert's opinions and provisions and findings are agreed to be binding and contractually binding upon both parties. This has the advantage, of course, of expediency. The processes can be agreed within a tighter timescale. Specific issues can be carved out of the arbitration and handed for the expert to determine. There is no right of appeal from the parties, which of course is the downside because parties will want to have their ability to test. The expert determiner would not be presenting findings. It is a different set of processes from the normal arbitration process. However, in terms of trying to produce something in an expeditious and speedy way, which is something that was clearly a concern from the mentions in the previous session, it can be something that actually makes the process a lot quicker, faster, and cleaner. Next slide, please. So we believe that the guidance that we've provided for technology-related dispute resolution and the appointment of experts and of arbitrators provides guidance of who and where and how and what can be done, and importantly, effectively and expeditiously and appropriately used in order to assist the tribunal in coming with an appropriate award. And Thank you for your attention and thank you for the support of Penguta in this presentation.
Thank you, Chris, and thank you, Kwenguta. I think as you have highlighted, draft provision 5 highlights when and how, who would be engaging with experts, how the tribunal would be engaging with those experts, and a number of other topics, whether the role of the experts in the proceedings, what would be the effect of the legal determinations by the experts as well. So I would like to open the floor on comments on these two on draft provision 5, and also on the point that Kwenguta mentioned, that it would be preferable to have a sole arbitrator with being supported by the experts as the approach taken by draft provisions 5 and draft provision 2. So first, I'd like to open the floor on the approach to be taken, on the number of arbitrators and how to engage the experts, and possibly comments on paragraphs 1 and 2 for the time being of draft provision 5. Switzerland, you have the floor.
Thank you, Mr. Chair. We fully support the proposal of having as a fallback position or the default position a sole expert. That gives the flexibility to enlarge the tribunal if more complex disputes require, but the fallback position should be a sole arbitrator to have the advantages of speed in that respect. With respect to experts, we think there is a very important aspect in technology disputes, that the technology often is best understood or explained by the members of the parties themselves. And there are cases where nobody else but the parties, or only one of the parties, fully understands or fully masters the technology. Therefore, a point that needs to be given careful consideration is who are the experts, and limiting expertise to independent persons can be risky, especially in technology that is newly developed. So I think that requires further consideration. How can the expertise in the teams of the parties be properly used, making allowance for the fact that they are parties? This, of course, influences the assessment of their opinions, but not to exclude this expertise. I think that is something that arises in other arbitrations too, but it is something that needs given particular attention. The way how the provision now is drafted doesn't seem to be very clear in the distinction between party-appointed and tribunal-appointed experts. I find some overlapping, and in particular, I found the influence of a certain practice in the English common law background, that the experts are appointed only after the parties have made their case, and that the courts or the tribunals have an influence on this. I think, from my perspective as counsel, this is not acceptable. I want to present my case with the experts I have selected, and they are part of my case. So I think that should be taken into consideration. The fact I've heard that the tribunal should decide whether a party can use an expert. I think that is something that may be in some jurisdiction acceptable, in others it is not. The last point is the question, who is a neutral? I know the term from American practice, where the neutral is the third arbitrator, the chair of the tribunal, but I have no, I don't know how the neutrals get into the clause on experts. Perhaps that could be explained. Thank you.
Thank you. Franz, you have the floor.
Thank you very much for the presentation. I wanted to partly echo what was just said by the distinguished representative of Switzerland on several points. Firstly, I do get the impression that looking at the use of experts and the modalities for that, that largely depends on the legal tradition. In some legal systems, in theory, it's the judge or tribunal that appoints experts. In others, though, it's only the parties. One of the advantages of arbitration and it provides enough flexibility to be able to adapt to different legal traditions. So I don't know if then it would be good to come back to this level of flexibility at some point. Also, I think that perhaps in terms of technology, unlike what we think there are, and if a tribunal chooses an expert amongst the declarations on and the independence of the experts, we also need to ensure that this expert can explain if they are part from a particular camp or if they're in a different area. So in terms of nuclear fission, on the form that the Tomakaku chamber should have, that allows us to keep nuclear plasma in a good state. Well, there are different possible options. There are those who believe that the donuts would be the better than a sphere, for example. So these are different beliefs systems. So we shouldn't think that if we choose an expert with one set of beliefs, then a tribunal takes a decision without being informed of the existence of other views. So this could be avoided if we allow parties to come with their own experts. There's another point that's not covered in much detail in this provision, unless I missed it, but this impression I get is the question of the modalities for communication between experts and the tribunal. Would the tribunal is able to consult with experts outside of the parties, or would any communication between the tribunal and the experts, does that need to be done with the parties' knowledge? In my view, this is a question that's extremely important, and I know that in other fields, which makes me think also that this provision is perhaps not specific to new technology-related disputes, but particularly in terms of construction arbitration, there is thinking underway at the moment in different institutions on the possibility for an arbitration tribunal to have a third party that they can consult outside of the parties to the dispute. So I'm wondering if the expert that this provision is mentioned in this provision 5 could be this third party. And I think sometimes that there's sometimes the expert need to have full knowledge of the case in the future version of this draft provision 5. Thank you.
Thank you for posing those questions. I have the request from Israel on the platform.
Yes. Thank you, Jay. As we see it, the appointment of experts is a core element of this suggested instrument. Since the issue of technological expertise was dominant in the consultations we had with experts, both from the tech sector and the legal sector. Arbitrators selected by the parties could have some technological expertise, but they cannot be expected to have proficiency in every aspect of every technological issue at hand. As a balance between a neutral expert and an expert chosen by the parties, it is possible to have a sort of a mechanism agreed by the parties for the selection of the expert. This could possibly answer the concerns raised by the distinguished delegate of Switzerland. And in the spirit of brainstorming, this is our suggested idea. Thank you.
Thank you. Unless are there any other requests for the floor? If not, I would like to give the floor back to our two speakers, the experts who prepared, and possibly have comments on the responses. Comment on the comments that have been made by the three delegations. Chris?
Thank you very much to the distinguished contributors and their comments. Again, in the spirit of this being a working document and something, I think the points are very pertinent. The point of being flexible with different traditions is well made, and the issue of differing opinions is also an important one, but probably not one that is, as an expert, is something that is an easy thing to resolve. But when you've got two very distinguished people, one saying that plasma should be stored in one point and one saying another, it is a very difficult point for when I've sat as an arbitrator or things to actually hear and to understand and process both arguments. You try and understand both points of things, but I fully accept the point and the argument. And I also accept and understand and very much recognise the point made by France, which was that there needs to be guidance on consultation, how the experts can conduct themselves and contribute and discuss with the arbitrators who should be present, who should be discussing things. I think that is something that definitely needs to be added into any future draft. Those are my comments, and thank you again for the opportunity. Klanguta, would you like to add to any of those points?
Yes, indeed. Just a brief comment on my side, with many thanks for the comments that were made, and they are very useful. I would like to respond to the Switzerland delegate point regarding the reference to experts and neutrals. This is a reflection of a very important, we considered, input that we try to make in the way in which we suggest that the input of experts is to be treated, and that is either as an expert with a non-binding point of view who is contributing to the understanding of the party's position on technical side, and that is the expert. And then is the so-called expert determination, which we tried somehow to refer to as being conducted by an expert with the role of neutral. And that expert, in that case, will decide in a matter that it is binding, contractually binding, similar for those that are familiar, for instance, with FIDIC contracts, with the expert determination that is made in the engineer's determination, for instance, in FIDIC, except that in this case it is a neutral and it is not appointed by one of the parties only. So the concept of neutral, maybe it should have been, and maybe we can evolve in this respect, saying an expert neutral or a neutral expert. Maybe we can combine the words in order to be more explicit, but the reference that we tried to make was of a different role than then just to assist the arbitral tribunal understanding, but it was basically to go to the heart of the technical issues and decide on them. And that was the result of a prior discussion between the members of this group of contributors to the document that it is presented to you for brainstorming. And that was whether it wouldn't be a possibility for the tribunal to have a composition that would be sequenced in time from moment 1 to moment 2. In moment 1, to have a number of the technical issues decided by some arbitral tribunal, and that arbitral tribunal would be made of technical background arbitrators to decide on the technical issues, and then to move to the legal issues in a second step with a different composition of the arbitral tribunal. And in the end, we realized that the best way that we can deal with this idea is actually to use with the concepts that we already have without totally revolutionizing the concept of the proceedings, classical arbitration proceedings. And we try to incorporate the expert determination into the sequence of decisions that are to be taken in an arbitration on this document referred to as the neutral. We understand that maybe the way in which we drafted is insufficiently explained, and we are happy to contribute more with explanations whenever needed. But at least in terms of our background thinking, that is what I was able to contribute at this moment to the discussion today. Thank you so much.
Thank you, Kanguta. I think we do have to clarify a few points in the provisions of party-appointed experts, and neutrals, which would need to be further elaborated as we prepare a second or a revised version of this draft provision. With that, I have a request from Switzerland. Switzerland, you have the floor.
Thank you. These explanations by Kanguta were very useful. The conclusion I draw from them is the word neutral is another word for what was in the explanatory note, the expert determination. So the distinction between the two categories is that one opinion of the opinion of one type of expert is binding on the tribunal. The expert determination, an issue is submitted to an agreed person. That person makes an opinion, and the tribunal is bound by it. And that is expert determination. We have a technical term, and there's no need for a different term. The other one is the question of to what extent does the opinion of party-appointed experts or a tribunal-appointed expert is binding on the tribunal, or whether the tribunal itself has to absorb the knowledge and integrate it. And there, the question of consultation between the tribunal and its own experts, and possibly also with the party-appointed experts, is a very critical one. But I think we should start with the opinion, or with the point that the tribunal members have sufficient knowledge in the technology applicable in the field, in the dispute, that they themselves can form an opinion. They are not experts, but they should be able to absorb and transform the expert information into their opinion. And then the distinguished delegate of France raised a very important point, this question of communication. I have not received any response from our experts how to deal with the expert knowledge of the parties, and how this can be brought into the procedure. They're not just experts, they're not just witnesses on facts, but they may know the procedure or the technical issues better than any expert, and I think that is a point that should be given very important attention, especially in a field where we're talking about technology, and I think that is one of the specificities of technology disputes, that the parties sometimes know better than any professor at a university. Thank you.
Thank you. Are there any other requests for the floor? I would like to open up the discussions on the draft provision as a whole. There are some other elements. Of course, we were talking about the neutrals being appointed by the tribunals, being independent, how to provide the information, the legal effect of the determinations made by experts, expert determinations. So if you have any comments on draft provision 5 in general, we'll be happy to take them on board. France, you have the floor. Yes.
Merci.
Thank you. Just to come back to one issue, I think this provision is very interesting. Like all provisions, of course, it can always be improved upon, but the work is already quite interesting. But on the specific nature of this problem, namely technology-related disputes, I'm not sure we should just limit it to these types of disputes, because I can imagine that this very same provision could be quite relevant when it comes to quantum experts dealing with damages. There are a number of arbitrators who were trained over time in economic theory, and they became more and more knowledgeable. I think this provision could be very useful for any arbitral tribunal dealing with assessing damage. And I think that this provision then, in that case, is not necessarily specific to technology-related disputes. But, and I'll just end on this point, it's still quite interesting.
Thank you. We have the request from Uganda.
Thank you. Thank you so much to the Secretariat and the moderators and presenters we've had this morning. When we look at draft provision 5, I think when we come to discussing issues of technology and finding experts, sometimes I think it will be important, this is just a comment, that we need to find a balance between experts in issues to do with the law, a discussion, and also those who have a background in technology, because sometimes if we don't find a balance between the two, we might find that the experts are not able to assist in solving the dispute or giving their opinion in an independent manner. Thank you.
Thank you. And thank you. I think that was one of the issues that the experts had discussed. Actually, Kunguta may come up on this, but whether we should work on the appointment of the arbitrators themselves having technology expertise, whether the work should actually come up with a roster of people who are actually technology specialists we can refer to. I know that there have been other initiatives by other organizations to have and come up with such a list, but we did not take that path because we are a legislative body and we do not actually have rosters of arbitrators. So I just wanted to mention that balancing the legal expertise to administer arbitration and also with the technical expertise is something that we had tried to seek. And one of the approaches that we are presenting is the arbitrators being supported by technology experts in draft provision 5. So with that, are there any other comments on draft provision 5? Any other closing remarks from Kunguta or Chris?
Yes,
Kunguta,
just
yes.
one, yes, if I may, just one very brief comment. Indeed, this is the core part of technology disputes, the knowledge in technology. And this knowledge is to be shared between the tribunal, the parties, and the way in which the parties present their evidence, which indeed, as the Swiss delegate has rightfully mentioned, may be divided in two. Namely, on one hand, we have the experts that can explain technical issues to the tribunal, but then we may also have witnesses or party representative as witnesses explaining other issues. But in any way, whenever we look at the matter, the core characteristic of this type of disputes is that in the end, those who have to decide on the matter have to understand the matter. And the matters are not on general knowledge level. And actually, this is the difference between just technical knowledge and technology, advanced technology knowledge. The fact that it is not common knowledge. So you need to have a high degree of understanding on those issues. So my view in this kind of disputes is that the balance between the participants to the disputes has to be achieved, and it cannot possibly be treated as a matter of subsequent importance to the legal knowledge. It is of utmost importance in these cases. Thank you.
Thank you. Chris, your closing remarks?
Thank you very much to the Secretariat and the opportunity, but also for the provisions from the distinguished delegates. The comment made recently by the distinguished delegate from France in relation to a number of these provisions being applicable not just to technology disputes, but also to more general disputes is very well made, and it is one that I wholly endorse. Thank you all very much for the comments. We will take them on board, and maybe at some point we'll have the opportunity to return with improved versions. Thank you.
Thank you. I think we have received all the comments on draft provision 5. We have some experts who will be actually presenting the other provisions, so we do not want to go on with the discussion. And unless there are any last-minute requests for the floor, we will adjourn the session now, and we will restart the session at 1 o'clock New York time. So thank you for your comments, and thank you for joining us in this brainstorming exercise. Sorry. 3 o'clock, not 1 o'clock, 3 o'clock New York time. Sorry. Thank you.